Law Subcommittee, and it is Tuesday, the 12th. It's sometime in the afternoon. Who knows when? As the time goes a little crazy, we're talking about House Bill 392, the wiretapping bill. And for the record, Holly, I did invite somebody from the MMHA to come. I don't know whether they're in the waiting room or not, but just to be able to participate if necessary. Delegate Stewart has an amendment, which he has provided to us. You guys all got a copy of it and a reprint. Delegate Stewart, you want to present it real quick?
Yeah, absolutely. I appreciate it. I'm sorry I wasn't able to join for y'all's last work session. I appreciate y'all's diligence on this bill. We submitted an amendment that was basically in response to all the issues that came up in the hearing. So the first one is that we wanted to make it clear, and I believe this is actually the last part of the amendment list. We wanted to make it clear that we're talking about the enforcement of fair housing laws and in the civil context, and we're not talking about criminal law. So that section reads that an interception made under this subparagraph may only be used for the purpose of enforcing federal, state, or local fair housing laws and is not admissible in any unrelated criminal proceeding for any purpose. The second thing we wanted to make clear by just removing some language is that we're not talking about wires. We're talking about the recording of people generally on people's phones. So this is not The Wire, the HBO show, which I love, but that's not what we're talking about here. And some of the language was a little bit confused on that subject, and we wanted to clarify that by striking some of the language that talked about wires. But then I think the most substantive amendment here actually is the brainchild of Delegate Phillips, which is that there was a concern that there should be an analog to the idea of probable cause. So not literally probable cause, because again, we're talking about civil, but some kind of initial showing should be required before a fair housing tester can start recording someone. The idea here is to prevent sort of phishing expeditions and to protect people's privacy from being violated. And so the amendment on that point you should have, but it basically says that this recording would only be available if the tester has, quote unquote, a reasonable suspicion that the housing provider or an agent of the housing provider is committing a fair housing violation based on a documented prior encounter. And the definition of documented prior encounter means a, quote unquote, call log, note, report, or other written testimony from a tenant or a fair housing tester based on an encounter with a housing provider or an agent of a housing provider within the last year. So here's the idea. Here's basically what we're trying to do with this amendment and the whole bill. There are three groups of people. There are three groups of housing providers that will be affected by this potentially. No. The first group are people who are innocent and they haven't been charged with anything and no one thinks that they're racist, basically. Well, that group will not be fished under this Delegate Phillips amendment, for lack of a better term. It's a Stewart amendment, but it's a Delegate Phillips brainchild. Under that amendment, we prevent the innocent from being subject to a phishing expedition and having their privacy rights arguably violated, even though they are not racist. That's the first group. So we hope that we're kind of taking care of those folks per the concerns of Delegate Phillips. And also, I see now Aaron Greenfield has joined the call per the concerns of MMHA. The second group of people are people who are innocent, but they actually have been charged with a fair housing testing or a fair housing violation, right? Under current law, people are charged all the time. These fair housing testers are already doing their work. We think this bill is fairer to all parties because it allows recording. That means that it allows recording, including for that second group, of times where someone was not racist, which means if they're charged under the status quo and they claim that they're not racist because they're not, we have to rely on the faulty memory and faulty post hoc written notes of a tester to try to determine if someone has violated a civil law. That's problematic, I think, for the innocent. This bill would allow us to have an actual recording so we could hear the context and we could verify the notes and the recollections of the tester. So I think it's more protective of that second group as well. And then for the third bucket of individuals that we're talking about are people who are guilty. We have actual racists who have been charged for violating a civil fair housing law. And I think this bill makes it more likely that those people are held accountable for the violation of our laws. So we got 3 buckets. The innocent, I think, are better off with this amended bill. Number 2, the innocent who have been charged, I think, are better off with this amended bill. And third, the guilty who have been charged, I think, are certainly not better off, but the public is better off having them held accountable for their actions. That's the bill. That's the amendments. I appreciate the subcommittee's time on this.
Great. Delegate Conaway, you have a question?
Thank you very much. Can you hear me now?
Yes.
Thank you, Mr. Chairman. So I understand the use of the term racist, but what about when there's religious discrimination?
Yeah, totally fair point, Delegate Conaway. I was just kind of being cute. Sometimes I try to be cute and I fail, and sometimes I try to be cute and I succeed.
I accept you. Thank you. Thank
Okay,
you.
thanks.
It's okay. It's all right.
There's all sorts of discrimination. It's not all racial discrimination.
There we go. Thank you.
I totally respect that.
Delegate Munoz. You got to unmute.
Sorry. Thank you, Mr. Chair. So this is a really interesting bill. And my question is, the way I read this is we're changing the law basically to allow for a setup. Like, we're obviously all against discrimination of all kinds and racism and people being persecuted for religious beliefs, and all of those things, and even political beliefs. But we're changing a really important piece of law just for someone who's testing whether or not people are breaking the law. And it's not law enforcement. And so I'm wondering if there's any other precedent in Maryland law where we're sort of creating a carve out for someone as a gotcha, basically. Is there any precedent for that?
I mean, Delegate Stewart will certainly answer. As far as I know, in a criminal context, there is no other precedent. So, but go ahead, Delegate Stewart.
Yeah, I appreciate that question. And I think, Delegate Munoz, I think that the concern you're expressing is the reason these amendments are in front of us right now. Because we did not want this to be something where it's a trap or a setup, and all of a sudden it's a gotcha, we just recorded you moment. And what the amendment before you is intended to do is to say that we're only going to record to provide some recorded evidence of a violation that we think has already occurred. We have a documented instance of someone violating the law in the past, and now we're going to record in the second or third or fourth or fifth encounter, we're going to get a recording of that person so that we can enforce our fair housing laws. Okay. And it's a delicate balance, right? On the one hand, yes, we want to be protective of people's privacy. On the other hand, it's illegal to violate fair housing laws, and we want to be tough on these civil enforcement laws as well. We don't want to let people walk away scot-free if they're injecting discrimination into the housing market. And that's a delicate balance. And that's what we tried to strike with this amendment. No fishing expedition anymore with this language in front of you, but an opportunity on the second or third or fourth encounter, not a gotcha, not a test, not a broad-based recording of just every single housing provider in the state, but only if there's a reasonable suspicion that there's been a documented prior incident.
So, Delegate Munoz.
Who determines what that
is? I'm sorry. Go ahead, Delegate Munoz.
Sorry, who determines it? Like, who makes that distinction? Like, it's not a court making this decision about whether there was a reasonable, probable cause or something like that. It's just a fair housing tester who's like a government employee.
Well,
deciding to record certain people and having this carve out. So even though it's like, it is still a gotcha because they have some sort of prior history where they've decided to go back again and record, which in any other area would be against Maryland law.
So we're talking about admissibility of evidence in a civil law context, which means that there is a huge disincentive for a tester not to obey by this amendment, this law that's in front of you, regarding making sure that that prior incident was documented. Because if they can't show that it was documented and then they record it in violation of the law, two things are going to happen. One, they're still liable under the Wiretap Act, so they could be prosecuted, right? Secondly, this evidence that they've worked so hard to get of discrimination, it's not going to be admissible in court. So they've done all this work to try to get this person who has violated our laws, who has been racist or sexist or whatever else is. And now, because they didn't abide by the language in the amendment around a documented prior encounter, that's going to be thrown out. And so absolutely a judge is going to be the one ultimately determining whether that reasonable suspicion existed based on a documented prior encounter. And if there's not proper documentation, then not only is the tester subjecting themselves to possible prosecution themselves by breaking the Wiretap Act, but all of their work's going to be thrown out because it won't be admitted into the court in the civil proceeding.
And so we're willing to put these government employees at risk for being criminally prosecuted if they get this wrong.
They're putting themselves at that risk. They are choosing to do that because they believe in a fair housing market.
And so our current laws don't allow us to fairly prosecute these issues?
I would say that there are currently prosecutions going on all across the state. There are fair housing testers that are working all across the state, and there are a lot of fair prosecutions that have happened. But number one, our status quo allows ambiguity around what someone said because we don't have the full context, because we don't have the recording. That's why the status quo, number one, I think unfairly treats housing providers, because they are right now, they are sued on the basis of people's recollections. And number two, I think our status quo is inadequate because we are probably leaving housing providers out there who are discriminatory, and we are not enforcing our laws to the fullest extent because we don't have recordings available.
I'm going to stop for a second because we're now on the bill instead of the amendment. Delegate Moon, do you have something on the amendment?
Thank you, Mr. Chair. I just want to clarify also for the wiretap exceptions that we're discussing right now that this is obviously an exception that's being made. The other examples that come immediately to mind are that in 2015 or 16, we broke the wiretap statute to make an exception for the police. And that paved the way for police body cams. And then just a few days ago, we created yet another exception by taking Delegate Grammer's bill that breaks the wiretap statute to allow for surreptitious recordings in the criminal context and to allow them in as evidence, again, to help victims of domestic violence and other assaults and crimes of violence get around that hurdle. And then thirdly, we are obviously, we voted again the downgrade from felony to misdemeanor. So there's admittedly a small number of these exceptions, but they do exist. And I would say we're clearly have been trying to break the door open on bringing the wiretap statute into the modern age.
All right. Is there any other questions about the amendment as drafted? So let's take a vote on the amendment. All those in favor of the amendment, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. Okay, the amendment passes. The amendment passes. Good. Anybody want to be recorded in the no for the amendment? Besides, okay, great.
Schmidt is no.
Schmidt is no on the amendment. Okay. We're going to vote before the end of the crossover. I'm not sure we're going to vote on this because we really only have 9 minutes. We got to get to Delegate Stein's bill, but I did want to give whether it's Mr. Johnson or Mr. Greenfield an opportunity to express concerns or your assent now with this amendment that does actually narrow this to a certain degree. So yes, Mr. Johnson, why don't you do it? Well, we're only going to give you like a couple minutes because I promised to end at 5. I got to make sure I do because we have 4 more subcommittees to go tonight. Okay, go ahead. You have to unmute yourself.
By the way, Mr. Chair, I'm going to run. I'll
Right.
try to be back when you guys vote. I need to go vote myself, though.
Go ahead. And
I appreciate
if we don't vote, I'll let you know that we haven't voted yet, and when we set the voting time, I'll let you know.
Or vote away. I'm good either way, but I do
Okay.
appreciate y'all's diligence on this.
Thank you. Mr. Johnson, you are on mute. If you would like to speak, you need to unmute yourself. If not, we're gonna go to, does Mr. Greenfield want to respond since Mr.
Sure.
Johnson? He might
Thank
be,
you,
he might
Mr.
be stuck. He might be stuck.
He might be stuck. And I do defer to him as someone who is a subject matter expert and could refute many of the kind of process questions. But, you know, as I said to you last week, this bill is so unprecedented, and it is antithetical to the whole notion of a housing provider having a reasonable expectation of privacy. Remember, we're in a two-party consent state. California tried to do this. The bill failed. I don't know that there's another state, I could be wrong, that is a two-party consent state that is going to open this up to fair housing testing with this kind of surveillance to housing providers. And we have concerns, as we expressed last week, with respect to the training. Remember, this isn't for government employees. This is for nonprofit civil rights organizations who would have this ability to wiretap in some form your communications as a leasing agent in what could be in a room that's more than 2 or 3 people, where those individuals have a reasonable expectation of privacy. It's really unprecedented. And again, I'm not aware of another state. California tried it. The language was struck from the bill. That's a two-party consent state, as I understand it, and the bill failed. I defer the rest of my time, if I could, Mr. Chairman.
I'm gonna ask a question since somebody's going to stop really very quickly. Does is it true that a tester who does this and does it fraudulently or without the proper, based on the amendment, that they could in fact be prosecuted?
This is Jim Johnson. I'd say the crime would be perjury. But I want to make something just kind of clear issues up here. For law enforcement, you're recording in a public place or a place where you allow public law enforcement, into that communication. Number 2, law enforcement for enumerated crimes can conduct that one-party consent. Usually it's sex crimes, by the way. The concern I have about what I did hear today, though, is what I'm not 100% sure what actually creates this ability to record. Is it one complaint from an anonymous citizen? Is that correct?
So according to the amendment, a documented prior encounter means a call, log, note, report, or other written testimony from a tenant or fair housing tester based on an encounter with a housing provider or agent of the housing provider within the past year. So this is not an affidavit. It's not a sworn document. And as Delegate Munoz said, it is not something that has ever been before a trier of fact or a judge.
All right. How this is different, when you make a statement to a law enforcement officer, you could be charged with making a false statement. So you can go back and memorialize and document what was said before you make that decision whether or not I have probable cause. And I do believe that in cases like this, you should have a neutral party judicial official make that decision. So I'm still struggling with how to get past that probable cause language based upon what I heard today.
Okay. I am going to, is there any other questions for either Mr. Johnson, former law enforcement officer, now an subject matter expert, so, or for staff on the bill? I think we're going to hold it. We've passed the amendment, and we're going to go to Delegate Stein's bill. We've got 4 minutes. I want to see what we can do, if we can deal with that one. So thank you very much, Mr. Slade. Thank you, Mr. Greenfield. Thank you, Mr. Johnson. We're gonna come back to this bill. Okay, Delegate Stein is in a voting session, so I am going to present his amendment. This is House Bill 1146, and there is an amendment that, let me find the amendment. Where is the amendment?
You put that one. 1146. It's in that same
11:40.
email.
You're not on mute, Mr. Delegate Phillips.
Oh, sorry.
That's okay. I do not have the amendment in front of me, but I believe, Holly, can you describe what the amendment does?
Well, we don't have an amendment. From what I understand, there was amendment that was suggested, that Delegate
right.
Stein was, wanting to get onto the bill to help with the fiscal concerns
Yes.
with regard to state agencies. So,
So,
yeah, I'll let you take over.
okay, thank you. I thought that he was providing an amendment, but he did not. Let me just do this real quick. Okay. I'm going to make sure this bill will it expands the existing statutory provisions to establish that certain indemnity agreements and agreements to pay the cost of defense made in connection with an agreement for management or operation of a building as a and a structure is against public policy. And it was explained very, very eloquently by Delegate Stein's witness. Right now, that policy is in place if you're talking about the something having to do with the not the management, but the arising out of the maintenance contracts or agreements, but not out of management or operation of a building. And the example was pretty simple as to why we need this. We wanted to exempt the amendment that's being proposed is to make sure we're exempting government entities. Does anybody have a question about the amendment?
I think also exempting government entities, Chair, for just that management and operational ad. We're just going to clarify that the management and operation, the new provisions only apply or do not apply to state agencies to alleviate that fiscal concern.
Okay, Delegate Williams.
No, thank you. And I think Holly answered my question because when you were saying governmental entities, I guess I was just looking for clarification on it. I know that there was some mention in the fiscal note about also municipalities, but I think it seems like maybe the impact on municipalities may not be as significant as it is with regards to state entities. So
right. Well, this isn't just state entities. This would include municipalities.
I mean, it would include private entities as well. I'm okay with the impact that it will have on private contracts and things like that. I just wanted to make sure it wouldn't hinder any state or local contracts. That was my concern.
And the amendment does that. That was based on.
Well, it sounds like it just impacts state contracts. I guess and maybe I'm offering an amendment to the amendment.
Right. I thought that the amendment would say governmental entities. Is that correct?
I think that the suggestion was state agency. I have something drafted. Let me send it over to Gabe and have him screen share it. And then if we want to tweak that language, we can go from there. Okay.
Okay.
Let me do that.
All right. Is there any other questions or thoughts about the bill generally? We can talk about the bill generally. All right. So what I'd like to do is, and this could be, we can do this as a straw poll. We can do this as depending on what we get from Department of Legislative Services as to how to make sure we are inclusive of all the government agencies that are entities that need to be. Is there anybody opposed to the amendment? Great.
I mean, I think
Delegate Munoz is opposed to the amendment, and Delegate Grammer is opposed to the amendment, regardless of whether it's, and Delegate Erican, regardless of whether it's for all just state agencies or all governmental entities. Okay, got it. So that will be duly noted. If and when.
Can I ask a question?
Yes.
Yeah, okay. There's just a lot of like exemptions going on. Can someone just explain in practice what the heck is going to happen? So we have that car driving person example where they
Somebody
hit
worked, right.
somebody on their way to an HOA meeting.
Right.
And now the victims can sue the HOA for the person who was going not just to the meeting for some subject area, but to other subject areas that we're adding.
Right.
Or what are we actually doing is we're indemnifying them from being sued. So
No.
we're protecting the HOA from that, but we're going to exempt the government from being sued. Is that what I'm understanding?
So you described the bill pretty well, as originally introduced, that yes, you are indemnifying the HOA, but not necessarily the management company. Management company would still be on the hook.
Right, of course. Okay, yeah.
And
So now with the amendment.
The question is if a government agency, instead of it being an HOA, it is a government agency, should the government agency, I'm sorry, instead of the management company, it's the state. And the question is, should the state allow the HOA to be exempt or not? And what we're hearing is that the state believes that this is going to have a fiscal impact. Whether it does, doesn't, and whether it's right or wrong, that's what they're saying. So
okay,
I understand why
is it an HOA?
Hmm?
In that situation? I mean, I don't think the state runs any HOAs, do they? I mean, I'm just thinking about like public housing, right? So they have public housing. Let's say there's a management company. The guy is on his way to a public housing facility. He kills somebody. Now the person he kills can't sue the state?
No. I mean, that's not what this bill does. If you want to do your own legislation, you can. What this
No,
bill
I'm just
say
asking. I just want to make sure I know what's happening.
Is if there's some sort of entity, let's say it's a nonprofit or for-profit that runs the housing unit, the housing development, and the state is the one who manages it.
The state is that a thing?
Well, according to the fiscal note, and Holly is looking into this right now, but or the municipality.
Yep, I'm trying to get it to Dave. It'll be 1 second. And this is just a draft one that we can move around, but at least it'll give some context.
Okay. Maybe.
So, yes, Delegate Williams, did you want to chime in?
Yeah, I just wanted to chime in, Mr. Chair. I was just going to say, maybe, I don't know about the state, but I'm just going to use Montgomery County, for example. I know Montgomery County owns various properties throughout the county that they also rent for like below market rent, for an example. I don't know if they do or don't hire a management company, for an example, to deal with the management of those properties, but that's an example where a governmental entity may have a management company that they've hired and retained to manage a property. And I guess with this bill, the way it's originally drafted, if that management company were to seek indemnification, if this bill were to pass, and the management company were to seek indemnification from Montgomery County, this bill would say Montgomery County cannot indemnify the management company. Under the amendment, if we phrase the amendment so it includes counties, then Montgomery County would have to indemnify the management company, provided the management company is engaging in an act that makes sense.
Yes, I believe that is correct, the example you gave, but this is really for I think the intent for the state and the counties is the reverse, which is what I was trying to explain is that if the counties and the states do not want to make indemnification against public policy for management, they do not want to. So that means that going back into our law school logic games, that if the state does not want to does not want to allow does want to make sure that indemnity is available, they want to make sure that they are protected from the lawsuit and can pass it on to the HOA or to the property owner. And that's the way I read it. And I think that's the way that it's drafted. Holly, I hate to put you in a spot, but if we need to hold it a little bit, we can.
It's up to you. What came up at the hearing was the state agencies such as Department of General Services, Maryland Department of Transportation. Actually, there's others listed. They were worried, and the fiscal note
Reflects it.
reflects that the magnitude, because right now they do allow this. So if the management and operation components needed a carve out for state agencies to be exempt, that's kind of what this amendment would imply, that they're not under, and then the fiscal note would be okay, and then these agencies could continue using the leases that they already have, or the contracts that they already have that have this this provision already carved out. So I mean, we can hold it if you want, or this is what was discussed at the hearing, just making sure that it was just applicable for private contracts.
I would love to move the amendment, or have somebody move the amendment and see where we are with it.
Move the amendment, Chair.
Second.
Is there a second? Okay. All those in favor of the amendment as drafted here, please raise your hand. And I understand 1, 2, 3, 4. I have 4, 5. I have 5. All those opposed, let's make sure. 1, 2, 3, 4, 5, 6. The amendment fails. Okay, so we are not going to exempt, we're not going to exempt governments. Now, we can do some further research on this and see if there's a change of heart. I'm not going to vote on this at this point because I have a feeling that if we're gonna, that maybe we want to just hold the bill and make it correct or make it better explained. Is there any comments on the bill? And we have to get off of here. We're now 9 minutes over. Any more comments on the bill before we let it go?
Yeah, can we just like do some kind of flow chart? I'm sorry, I still don't.
Here's what I'm going to get
mind-boggling.
I'm going to get a flow chart, an example, and use an example that both includes and excludes government agencies, so you can see it both ways.
Perfect. And then if we can get a better grip on that, maybe we can reintroduce it if we think that it's
maybe
still
I'll have
reasonable.
somebody who voted against the amendment can maybe reconsider the vote by which it was taken, if that's appropriate. And if not, we will go forward. All right. Thank you all very much. Get ready to get to your next subcommittee. We are adjourned.